Hiring Happenings is the new podcast from Recruiting Gym, bringing you hiring news every month with a pestle twist.
Sponsored by Monster.
Welcome to our fifth episode of Hiring Happenings with a pestle twist. I'm Angela Cripps, the MD of the Recruiting Gym. Every month I have two guests from the field within recruitment with lots of knowledge on the topic. So the pestle is political, economical, sociological, technological, legislative and environmental. As it's the fifth month, we're on the fifth letter of L, so legislative. I'm joined today by Shazia Imtiaz from APSCo and Declan Bradley from Doyle, Clayton. Fantastic guests to have on here. I'm going to get them to introduce themselves. So Declan, let's start with you. If you could let everyone know what you do, but also what got you into legislative side of business in the first place?
Wow, it's quite a big question. Maybe to start with that, the background. So hopefully not controversial, but I grew up in a place where there were quite a lot of human rights abuses, things like that. I grew up in the bauxite and dairy in the 80s, basically. So it was kind of driven into at that stage that there were things that had to be addressed, and the way they addressed that could be through the law. So I was very interested in human rights growing up, and very like you are when you're young. You're very virtuous and you want to change the world and all that stuff. Now there was that background to wanting to do law and wanting to do human rights stuff, and I did do it at uni. Realism sets in, and you end up going down the corporate route, and I ended up going. No, I wouldn't say the opposite. It was a very good firm, but it was a big international corporate law firm that I got into after uni. And I joined Doyle Clayton, which was a smaller firm where I felt like I could make more of an impact. And a lot of stuff that I had done before was with startups. And that actually led to me doing a lot more recruitment work because there was a lot of recruitment startups that I ended up working with. And although I'd done some recruitment stuff before, it was really at Doyle Clayton where it took off because I was helping lots and lots of companies with the recruitment issues. I'm now kind of risen through the ranks, and I'm now a partner at Doyle Clayton, and do lots and lots of recruitment stuff here. And I head up the recruitment team, the recruitment sector team in Doyle Clayton. A wide sort of breadth of services. We have mainly employment and immigration as the key focus, and then that sort of leads into the recruitment piece quite a lot because obviously the recruitment's all about the workplace, isn't it?
So I'm so glad that we've got you within our industry supporting the recruitment side, and that brings me to Shazia as well, because obviously you work for APSCo, so please tell us about what you do for them.
So I'm General Counsel at APSCo, Association of Professional Staffing Companies. We're an international trade body providing services to SME recruitment companies as well as larger international organisations. But how I fell into law was very much the need to problem solve. So I've really enjoyed the aspect of finding a solution to any issues that clients face. And that's what drew me into law. And I started off, like Declan, in private practice, was in private practice with various law firms for 10 years, and then moved across, as they say, to the dark side for a bit more work-life balance in-house. And I've worked across a number of industries, not solely recruitment, but I very much enjoy recruitment and employment law. And that's really the main emphasis of APSCo.
Fantastic. And to have these bodies that are there to support our industry, to help us. Our first session obviously was politics, and we had Kate Shoesmith on, and we've realised that the politics affects everything that we do here. We're going to try and keep out of it a little bit on this one, because actually our government has dissolved as of today. We have no politicians as it is with the general election coming up, but the legislation that's on the cards, oh my goodness. So I was so glad that we've got this here, because there is so much going on. So Shazia, I'm going to start with you with regards to the Employment Relations Act, the Flexible Working Act. Can you let us know what's going on with that at the moment, please?
Yeah, absolutely, sure. So from April of this year, there's been a change to the flexible working requirements. So as of April, you no longer have to work for 26 weeks. It's a day one right to apply for flexible working. You can make 2 requests in any 1 year in a 12-month period. Again, it's not a right to flexible working, it's a right to request it, and it's a consideration that employers should take into account and really consider the application properly. There are, of course, statutory grounds to refuse it, but the employer can't just flippantly reject the application. They've got to consult with the employee and meet with the employee to discuss it. So that's it in a nutshell.
Declan, have you got something to add to that?
Yeah, so this is mainly pertinent to employees. So in terms of recruitment, it's probably not going to affect like agency workers and definitely not contractors. So it's more probably for internally for recruitment companies to be thinking about for their own actual internal staff. And obviously the flexible working right's been around for quite a while. It's just an extension of it really. To make it a bit more employee friendly. But no, the same sort of, I don't want to say get outs, but the same business reasons for rejecting a request still apply. Will it reduce the quality of the work? Do they have the people available to pick up the slack? Are they able to hire in people to pick up the slack? If not, no, those can be reasons to dismiss. I think there's 8 statutory reasons which will have to be provided in the response. So yeah, so it's been on for a while, but it's definitely more employee friendly now for sure. And if recruitment companies are, and they will be, of course, listening to this, then they'll need to look at the policies, because if they have a handbook and they've had a handbook sitting there for a few years and not looked at it, this policy will be in there most likely, and it will need to change.
Right. Now, one act that has been around a long time, and I can remember when I first started in my first week getting trained on this, is the Employment Agencies Act of 1973. But even then, thinking 73, I mean, 50 years ago. But what did we have before that? I mean, what was going on? Because the agencies have been around for 100 years or so. So the fact that it came in then. So what do people need to know about that?
So look, I suppose this is just a way to explain to recruitment companies that they are in a regulated sector. Because you'd be surprised, I kind of forgive these new startup type companies that come to me and don't realize that actually they are in the recruitment sector for one. And that's the people who might be, say, doing a platform to have PTs to people who need PTs, or tutors to people who need tutors, that kind of thing. There was a case that actually the tutors, a few tutoring companies, online tutoring companies, brought against the Employment Agency Standard Inspectorate, because the Employment Agency Standard Inspectorate was saying to them, you guys are recruiters and you're caught and you can't charge your work seekers, the tutors, for the service that you're providing. So they took the regulator to court, but they lost. And the courts agreed that those kind of middle person platforms are recruiters, and they have to comply with the relevant regulations. So you have those kind of new startups that might not know, and it's sort of understandable. But I've also come across, I think I chatted to someone who was a 30-year veteran and a consultant in the space, and they'd never heard of the conduct regs, and that's the Conduct of Employment Agencies and Employment Businesses Regulations 2003. I'd never heard of them. And there could even be criminal breaches for getting it wrong, So it is surprising that in this space, from the new people to the people who've been around for a while, they don't realize they're in a regulated space with a regulator. So maybe the regulator themselves needs to come out and do more instead of just posting their reports and their investigations on their own website, which people, if they don't know they exist, will never look at anyway. So maybe they need to come out and do more. To explain about this sector and to explain that it is regulated. And when I say regulated, obviously there's lots and lots of laws which will apply to any company in the UK. GDPR, Data Protection Act 2018, Bribery Act, all that stuff's going to apply to everyone, including recruiters. But specifically for recruiters, as you mentioned, it's going to be the Employment Agencies Act 1973. So the main thing in there, I haven't got a photographic memory to remember everything that's in there, but I suppose the main takeaway from that is that, one, it set up the legislative sort of imperative to put in place those regulations that I just mentioned. So that's where those come from, the regulations from that act. The act also makes it an offence to charge work seekers for work finding services. So it's a criminal offence. And I don't think you could throw in a jail as such.
Well,
but
that was my understanding as to why they came about in the first place back in the 70s, because agencies were charging candidates back then. And that's what finally put a stop to it was this act. Is that correct? Am I right?
I believe so. I don't know the whole history. I was born in '83, so I wasn't around when it came out. But yeah, I assume so. Obviously, there's exploitation, and when you have people looking for jobs, they're going to be desperate. Particularly maybe back then when there was less opportunity for people to do their own thing. There wasn't the internet, where you can go on the online these days and make a living some way, even without a recruiter. But back then, I suppose you probably needed a recruiter to find a job, and that gave recruiters probably a lot of power. So I can see the public policy reason behind that, and not charging people for that service. So that's kind of the main thing that came out of that, as well as defining what is an employment agency and what is an employment business. Because recruitment companies will tend to be one or the other, or both.
So just to let people know, because I always remember it by BT. So an employment business is temps, BT, and an employment agency is permanence. But of course, there are companies that do the both. So if they do both, do they have to define themselves as both, or do we just say employment agency at that point?
You will have to say in your terms and conditions, as per the conduct regulations, what you are and what you're acting as. So that's why you'll see in well-drafted client terms, we are acting as an employment agency for this service. For this service, we are acting as an employment business. So you do actually have to say. So that's something that should go in there for sure. So an employment agency is just what you said, really. It's introducing candidates to hirers who will then hire those people direct, and then use the agency. You stand off and you're no longer really involved in that contractual relationship, and you take your, whatever it is, 15 to 30%, or if you can get more, that's great. So that's kind of the employment agency side. The employment business is where you maintain a relationship with the work seeker, whether that's agency worker or a contractor, and then you basically parachute them into your clients who you then have the contract with. And then
I've now got a visual of the Queen parachuting in, like so we're just dropping people off.
Supplying,
that would be amazing.
Yeah, so you're supplying those people into your clients, and your clients pay you, and then you have your own separate arrangement to pay the contractor or the agency worker separately. So that's the two different models, two very different models. Some of the work that I've done recently is to help employment agencies move from being or add on even an employment business model to their existing business. Because I think, Shazia can probably talk more to this than me, but I think there's been more of a shift recently, to temporary type recruitment, because people didn't want the headcount because of the headwinds on their businesses. So It meant a lot of companies were looking at, right, well, how do we get into this more temporary space? And so they were moving to be an employment business. And I helped quite a big, 180 person employment agency, and they even not struggled as such, but no, it's a big undertaking for them, even with their resources, to really understand exactly what it meant. And it's a big change from being an employment agency to employment business. There's way more regulation on you. There's way more things that you're thinking about, more liability. You have to definitely change your insurance, all that stuff.
Yeah, Shazia, certainly. Whenever there's a recession, it goes temp, doesn't it? Because that should get stronger. The perm pretty much dies a death, and thank goodness we're out of recession now, and it's all moving forwards. But certainly from that temp point of view, a lot of companies really struggle with the payroll and the cash flow when they move from perm to temp, because all of a sudden all the money's going out before you get it in. And well, this is where it did change originally, where you've then got umbrella companies coming in. And I know there's regulations there as well, isn't there? It's changed.
No, that's absolutely correct. You're right. During a recession, there is a shift, and headcount, figures go down, and there's more temporary supply required. And a lot of temporary supply is provided through umbrella companies, and they really do provide really good support in the labour market, in the labour supply chain. However, we do have the odd rotten apple, as they would say, who are not compliant, and that does cause issues. At APSCo, we do recommend for our members to operate through the compliant umbrella companies, and it's easier said than done. And we sort of recommend FCSA or Professional Passport accredited umbrella companies because we know that they are audited regularly. The real issue is that some umbrella companies don't operate compliantly in the sector, and whilst due diligence does catch that out, it's not often so easy to spot. And we've been lobbying for regulation of the umbrella sector for some time, and we submitted to the consultation last year for regulation of the sector, a little bit more transparency as well. HMRC to provide a list of compliant umbrella companies, which they are a little bit reluctant to do, as that, you know, it's a bit of a challenge, and to sort of secure payments as well, because you probably have a lot of umbrellas that you're probably familiar with that sort of phoenix and disappear and then rise up again in a different name in a different capacity. So there are real challenges in the umbrella sector, but I want to sort of say again, they do provide a really good function, and most are compliant. It is the odd one or two that are not so compliant that cause the real issues, and those are the ones that we're really talking about here. So we submitted the consultation, and we're still waiting for the response to that consultation. But recently, HMRC did make an announcement a few months ago that they will be issuing further guidance on what good due diligence looks like, and also issuing a payslip checker tool, which is very welcome news, because that should be really useful for every body in the chain to make use of. And we're also looking for a fuller response to the consultation as well.
Fantastic. Okay, so this is all moving forward. I'm actually surprised they're not regulated from when they came out, because this is people's money, this is people's salaries. Yeah, you would hope there was some regulations around it. So that's great to hear. And certainly from an industry point of view, you're right. When they came about, it was another option for companies to utilise, which made a big difference. So if you've not looked at this and you're looking to get into temporary, then I think, yes, obviously connect with either Declan or Shazia here, or probably both, and certainly look at the information that they're sharing and the expertise, and we'll get those links in there for everyone as well. Take a moment just to say thank you to Monster UK sponsor Hiring Happenings with a pestle twist. They've been putting candidates together with Germans for 30 years now. It's their 30th anniversary. So thank you to them for sponsoring our podcast. Right, Declan, I'm coming back to you.
Okay.
We've mentioned the conduct regulations there, and that update in 2003. What was the biggest change, do you think, from those, and what's happening now?
They've been pretty consistent, those regulations, for the past 20 years, to be honest. There's been a few changes in them. One important change for employment businesses. So basically, as I said before, there's a lot of extra stuff for an employment business to think about compared to an agency. So when you're supplying workers or contractors in, there's a whole lot of stuff there to think about. So if you're supplying a contractor, if they've got a PSC, personal service company, then if you're supplying them into a big client, which probably you are, big enough to be caught by the new IR35 rules since 21, then you as a recruitment agent, recruitment company in the middle, you're likely going to be the fee payer to that PSC, personal service company. So that means you're taking on all the tax risk. If HMRC gets involved later, investigates and determines actually, no, this looks like employment, not self-employment, then they come to you. They come to you as a recruiter, because you're the fee payer. And if that client has done an assessment and taken reasonable care, that liability has passed to you. So you really need to understand the IR35 process for one, when you're acting as an employment business. If it looks like they're inside, or just straight away that they are agency workers, and you're supplying agency workers, whether yourself or through an umbrella company, and even through an umbrella company as well, then the Agency Worker Regulations 2010 apply. And so you have to have a compliant process for that. Okay, so that means that mainly at day one, you have to make sure that your hirer provides access to certain facilities like canteen and stuff like that. But the main issue is at week 12 of an assignment, agency workers, whether you're an agency workers through your own PAYE or more likely these days through an umbrella company, that they have to get paid the same as if they're hired direct and have all their entitlements as if they were hired direct by that hirer. So that means that you should have, if it's old school, some kind of spreadsheet between you and that hirer to make sure that and the umbrella company to ensure that everyone knows what that person should be paid at week 12. So then that's a whole lot of extra stuff to think about. So as that employment business, you might be doing the IR35 and you might think, oh, actually we'll use an umbrella company instead of IR35. It doesn't get you out of a compliance process because then you're into the agency worker regulations process. With the conduct regs, one change for employment businesses, and which cannot be opted out of, because the conduct regs can be opted out of by companies with PSC, so contractors with personal service companies can opt out, and you can actually get umbrella companies to be the corporate work seeker as such, so they and that individual can opt out, but no one can opt out of, I think it's Regulation 13A, which is the obligation to provide a key information document. Essentially, you have to tell an agency worker or a contractor, look, here's how you're going to be paid. Here's who's going to be paying you. Here's what deductions are going to be made and why. And then that you give that off to them. I'm not sure, I don't have any data. Maybe Shazia has some data about how often recruitment companies are actually complying with that. You know, there are free versions on the .gov website anyway, so you don't have to pay a lawyer to actually get those kind of documents in place. And it's probably one to do with your accountant. Don't ask me to be crunching the numbers about what people should be paid. So I just highlighted it there and highlight, here's the free documents on the government website, and then we'll speak to your accountant to.
I think Declan's absolutely right. The kids sort of came in during COVID, so a lot of recruitment companies, are not that familiar with it, and the Employment Agency Standards Inspectorate have restarted their inspections. Post-COVID, they died down for a while, and they have restarted last year. What we're told is that when they have carried out these inspections, the kid is one of the forms not being sent out. And Declan's absolutely right. You cannot opt out of that. It's a prescribed format. It's a one-page document. And the purpose of it is for transparency, so the worker knows exactly what they're receiving. But it does seem to be a challenge, even with a one-pager. It's not being done by all the recruitment companies. And I think some of the challenge is when you're using an umbrella company, you've got to liaise with the umbrella company to get the information to populate the kid. And often you're meant to produce the kid, as Declan has said, before you commence the work finding services. And again, you having to produce maybe a number of examples as best practice, for an agency worker, what that kid would look like, or when you're being supplied through an umbrella as well, what that pay would look like in a kid. So there are challenges with it, absolutely.
We'll get the link in there for that document so that people can just access that very easily. And it did take me back. It's the only time that I have actually dobbed in is my phrase that I use, but an agency to the EASI, temporary workers of ours came to work for us, and when they registered, said, can you please confirm that you won't dock all our wages if we miss a day's work? So it's like, what do you mean? And they were, well, there's an agency in our town that they give us 40 hours work for the week. If we only work 39 in the contract, what they'd got is that their rate would be reduced to £1 an hour, something ridiculous. And therefore, all these regulations coming in, national minimum wage, and certainly the confirmation to make sure, who's paying you and what are you getting paid beforehand? Because unfortunately, these practices were out there. So I couldn't sit by on that one. I did have to actually do that, and I believe they were shut down because all of the practices were just horrific. And we don't need that in our industry, do we? There are people out there that unfortunately are just in it for themselves and to get money, and they don't care who they hurt. So if you come across one of those, I'm putting it out there to you now, feel free, you'll sleep better at night, to actually inform the EASI, and we'll put that link in there as well as to who to go to.
Yeah, and the ESI, so EASI, it's a mouthful. So yeah, I've been involved with them, and on behalf of someone else, I submitted a complaint to them, and they do follow up. And they do get back in touch. I don't want to say the guy's name, but it's always the same guy that comes back to me, and he seems to be very responsive. And they do follow up. Now, you don't often find out. You don't get that much details about the investigation as such, but I think recruitment companies shouldn't be afraid as such of dealing with the regulator, even if they're doing something wrong, but they want to change. Because I think the regulator, and especially this guy, I did have a chat with him from an educational perspective, so he could tell me about their work, and they want to help people improve. They want to help companies improve. So it's not all about them running in like people probably think of the SCA or ever hitting people over the head. I think it's more trying to work with them. The people who are cooperative and want to work with them, of course. Obviously, they've got a lot of powers if people just don't listen to them. Now, they do have powers that they can wield. I don't think they've wielded that often. I don't know how much resources they have, but no, they are there. But ultimately, I suppose my message is the regulator's there to help, and they're there to consult with if you have any questions. And I find them quite useful in terms of, especially dealing with these people who won't accept that they are caught by the recruitment regulations and caught as recruiters. I found them very helpful because I've, on a sort of anonymous basis in terms of who I'm dealing with, I've emailed the regulator, said what people are planning to do, and then asked them, look, do you think they're caught? And obviously they don't give... They have lots of caveats, like we're not giving legal advice, blah blah blah. But we think that they could be caught by the regulations and come under our remit. And then that's helpful for me to take to these people and say, look, this is what I have to work with, and so you might want to be thinking about being compliant as well. And it has helped. So I find them quite useful.
They are very approachable, easy, for want of EASI. They're very approachable, and the conduct regs, when used correctly, they do provide a really good framework for recruitment companies to operate compliantly in the sector. So totally agree with Declan's views on that.
I think there's going to be some people listening that aren't aware of this. Like you said, Declan, you had someone with 30 years experience and suddenly like, what? There's regulations that I'm meant to be following. So please do look into it. You would hope the company is set up by the regulations and therefore they're following everything, they're doing everything properly, that your IT systems are all set up so that it does it properly. But you still need to know about all of these elements to make sure that you can give advice as well, or certainly you can answer questions when people come to you and you don't look like you go, I don't know anything about that. So another one that you're bound to get questions on, that's also happening this year, the Workers' Predictable Terms and Conditions Act 2023. Shazia, tell us about that.
Right, okay. So this essentially is for those workers that don't have predictable terms. We're still waiting for the regulation to come out later on this year. This act received royal assent last year. And what we understand is you'll not be on predictable terms if you are on a 12-month or less contract. So those workers will be able to apply for predictable terms and conditions. You have the right to put in 2 requests in a 12-month period. A worker will have to have been in a contract with the agency at some point in the month before the 26-week period leading up to the date of the request. So I think that is an important factor to keep in mind. And there's different requirements when applying to the hirer directly or to the end client directly. But I think the key point is that, again, it's a right to request, not a right to have. And again, you have to set out what you're seeking. And there are 6 statutory grounds to reject if it's not in the interest of business, if the work demands require different time frames, etc. It essentially came in for the 0-hour contract gig economy workers who needed a level of protection. I don't feel, subject to Declan's views, that it really will impact the professional end of the market so much, because the locum nurses, the teachers, they quite like their pattern of flexible hours and irregular hours. But essentially that is the right to make 2 requests in any 12-month period. The agency can reject that request if it meets with the 6 statutory grounds to refuse.
I am wondering how realistic that is, having run temp desks myself, having 1,500 temps out at one point, if they're applying for that, that it's so down to the market and the economy and everything else that's happening. You may have a plan as an agency and what you think, but it's not predictable in any way, shape or form, is it really?
I mean, the challenge is the admin burden it's going to place on the agencies. If you can imagine the number of workers on their books, and if in theory everybody can apply once they meet that qualifying period, it will be a huge admin burden. So, also putting in policies in place to deal with this as well, and procedures to make sure you meet the timeframes, because you have to respond within 1 month of that request. So I agree with you. How feasible it is, how realistic it is, we'll have to see.
I'm seeing here a gap in the market for someone to create an AI bot that can predict these things, take the information and go, okay, from what we know, here's the prediction, and do it from there. That may be what it ends up as, and hopefully that's some AI used for good. We will see. Yep, Declan?
I think on that, I think there could be a lot of changes potentially with that law. If Labour get in, there may be. So it's definitely one to watch the space to see how it's actually going to end up. But it's another reason why, like I mentioned about the agency worker regulations, that the main issue kicks in the 12 weeks of an assignment. And I think it's the same, Shazia, for this, isn't it? That if it's an agency worker making the request for more predictable terms, and I think they have to have 12 weeks of an assignment, of the same assignment. So you might just find lots of companies thinking, right, well, if we're doing agency works, we don't want them for 12 weeks, we only want them for very temporary things. So that could be an issue. So just something to keep in mind of and be mindful of, but also watch this space on that, because I think if Labour do get in, then this stuff could change quite a bit.
I think, Declan, that's right. That's a time frame if you're applying to the 12-week period in the 26-week time frame. So exactly, it's really challenging. But the regulation hasn't come out yet, and as Declan said, there may be changes to it, subject to what happens in the general election.
But that's what Hiring Happens is all about. It's like, what's going on? What do I need to be aware of? What do I need the heads up on? If I'm running a temporary desk, what is likely to impact what I do? And therefore I need to be having those conversations with my customers in case things happen that do make a difference, and letting them know as well is a great way of having a conversation, a bit more interesting, deeper conversation with your customers around regulations, around legislation that they should be aware of as well. And I used to find a lot of the time they've got no idea either. Certainly people, if they were hiring managers, if they were end users, then a lot of the time, they're not necessarily party to all this, or they don't keep up to date with it. So as a recruiter, you have an opportunity here to have these conversations and let people know. And that's why we set up Hiring Happenings, because we wanted to bring experts in to let people know, what's going on at the moment? What can I be having these conversations with? What do I need to do a bit more research on? So all the links will be in there to find these for you. Declan, I want to come to you with regards to your experience with recruitment agencies, because you get to see where it goes wrong sometimes and where people haven't been aware of these things. So can you share any information around that?
I suppose one of the main things, as I've touched on already, anyway, has been these companies not understanding that they are a recruitment company. So I've seen that. I've seen quite a lot of tutoring companies, or even like just locum type companies that just don't want to admit that they are recruitment agencies, and then setting up things which could literally be criminal, because some of these people have wanted to charge the work seeker, wanted to charge the contractor who might be on their platform for them finding them a service, and they're trying to copy emails like, I think it's like, if I can name names, so big companies, if that's okay.
Yeah.
So there's big companies like Fiverr or Upwork, I think people like that who are not based in the UK. And I think they charge work seekers. They charge the people on the platforms, as far as I'm aware. And then so I get these startup type people come and say, but they're doing it, it's okay. And I'm like, well, I don't know about that. So I actually went to the regulator and and talked about these people and said, look, they're not in the UK. And he said, well, we can't do anything about that because they're not here. So they can kind of do what they want, even though they have a platform which kind of operates here. So that's been a challenge. And I have not got some clients because they just didn't like what I was saying. And I assumed they went to another lawyer who didn't, without being arrogant, didn't know as much as I did and wasn't as in close contact with the regulator as I was. And they just, classic, went round probably however many lawyers until they got the answer they wanted, you know. So that's been a real challenge, helping people understand that there are regulations here, and it's not always the Uber model of break things and fix them later. You know, no, if you need to be compliant, because there's some companies, for example, no, they might accept that they're a recruitment agent and caught by the regulations, but they don't want to be an employment business, for example, because I say, well, that means AWR, IR35, and like, don't that. So they say what we're going to do, we're going to have this platform, and it's going to be agency where the hirer still has to have their own contract, and we'll set up this whizzy thing that there's a contract created on the platform, and then all the payment flows through our website to everyone. And it's like, well, you know, there's a certain regulation, I think it's regulation 6 or something like that, that you can't, of the conduct regulations, would say you can't be involved as an employment agency in the payment to your candidate. So there's stuff like that comes up where you have to kind of think outside the box, and hopefully the regulator was really helpful with that, because the regulator, I have a handy email from the regulator setting out how things like Stripe Connect can potentially be used to allow stuff like that. So it's those are the main challenges. Basically, these new type companies who don't fit the mold of a traditional agency and are trying to do things a bit differently, like an agency who's basically doing temporary. And like, I mean, temporary in terms of the person might work a day or a locum style, you know, and trying to do be an agency in that world. And how does that fit in with the regulations, and technology can help, it seems. So that's basically where I've had the main challenges. New types of companies that are in this space, and how does, as we talked about, old regulations actually fit with that. So that's kind of been my main challenge.
Well, I mean, we welcome all of these type of companies. We love having innovation in our industry. It's interesting to see that they don't see themselves as part of our industry, and probably until a little bit later, or someone like you that points out, well, actually, no, you're recruiting people, or you're finding job seekers for people. And I'm thinking like Checker Trade and things like that all of a sudden are coming into my head, because again, they're finding a local person to do work for you. So I don't know how the payment works on that, but I've suddenly realised, Fiverr, it's a recruitment agency in an essence. Shazia, what are the type of things that people tend to come to you with that others, it would be helpful for them to know really beforehand rather than afterwards?
Absolutely. I think what we find with our members is sometimes the challenges they face are where you have to get the information from another party. So for the AWR, our members need to contact the client to get the information, the 12-week comparative information. But often that can be a challenge. And we sort of advise our members to make sure this requirement's in the contract. So it's a lot easier to, there's a contractual obligation to get that information from, and the client has to make it available. There are also challenges with the kid, getting the information from umbrella companies, or factoring that process in to make sure that can be completed. So a lot of recruitment companies want to operate compliantly in the sector, but they face some challenges where things are not directly in their control. So we advise to make sure that your contractual processes allow for that obligation to be included, so that you can be fully compliant with the legislation and regulations.
Well, I'm hoping we haven't scared a lot of people off from our industry, but there is people that are working in it that are going, okay, I need to do some more work on this. If you want an easy life, then it's a recruitment agency, isn't it? And work as that business. But if you want to be there through the thick and the thin, and hopefully recession proof as well, then the recruitment business is where you need to go. And I can remember 2 years ago pushing people when it was 22 and it was also high and there was so much business. We know that's never going to continue. There's always going to be the ups and downs in the market, and therefore we're saying, right, if you've not got a temporary or a contract market at the moment that you're working with, then yeah, definitely look into that. But of course, do your due diligence beforehand. So on both your websites, your LinkedIn's, there's lots of information for people, isn't there, to explore all of this information if they are looking to get into it, like those startups you mentioned, Declan. I get people contacting me saying, I want to start a recruitment agency. They've got no experience, never recruited, and have no idea about the legislation that's there. What would be your one piece of advice if someone was looking to start up either an agency or a business? Declan, I'll come to you first, and then Shazia, I'll come to you.
Well, if I can do a self-plug, they can come to me and have a chat. So I have, if they go on our website, type in Recruitment Law UK, even I should come up, and then you can book in a time to suit you, and there's no cost, and you can have a half an hour chat, and then we have that chat, and I tell you about how we can help and how we can help and how we're helping those smaller new recruitment companies is on a subscription basis. So it's 100 quid plus VAT a month as a buying cost, and then there's other benefits, including fixed fee, very affordable fixed fee packages to get you set up either with your employment agency, client terms and candidate onboarding documents, or employment business, or both. I've got like an all-in-one template kind of thing. So that's a good way to get started. So you can come and chat to me. But it's really, you do need to chat to a lawyer, I think, and also an accountant, any kind of startup, no matter recruitment or otherwise. An accountant's your best friend, because they'll help you understand your financial strategy and what, if you're doing any kind of whizzy tech stuff, especially with the recruitment, maybe you can go for certain reliefs and all that kind of stuff. And if you're thinking of bringing on external investors, and there's certain ways you can get set up with relief schemes for your investors, like SEIS and things like that. So chat to an accountant, chat to a lawyer, and of course chat to the trade bodies as well.
Well, I'm glad you said the accountants as well, because our training session, the Monster training session in June, is with Marie Pegram of Recruitment Accountants, because yes, we got a lot of questions based around that. The trade bodies then, Shazia, what would be your piece of advice?
I'd say to anyone looking to set up in the recruitment company that it's an excellent sector to be in. APSCo have a lot of resources. We have SMEs as well as large organisations. We sort of cater to each of those. We have resources with updates in legislation. We have help desks, accountancy help desks, as well as legal and international and US. So there are a wealth of resources available, and don't delay, set up.
Fantastic. I think that's probably a good place to end it. Thank you so much to my guests, Shazia, Imtiaz and Declan Bradley. Really helpful. I think a lot of people are going to be going, okay, there's a lot more to this than I thought. So let me go and get on all of these links that we're going to share for you. Okay. Thank you so much. Bye-bye.